Okay. So welcome everyone to this presentation hosted by Housing Court Answers on deregulation risks for rent stabilized apartments post HSTPA. We are joined by three amazing presenters today. I don't know if maybe you want to introduce yourselves um, with your organization. Um, Maybe we could start off with Sam.
Hi, I'm Sam Kira. I'm the Director of Litigation for Communities Resist. We're a nonprofit legal services organization helping tenants and groups of tenants primarily sue their landlords for repairs against harassment and discrimination in Brooklyn and Queens.
Great. And then Natalie or Parker.
I'll go first. I'm Natalie Goncharov. I am a senior paralegal advocate. I work at Brooklyn Legal Services, specifically in the Tenant Rights Coalition, where we work with community-based partners to advocate for change and help sue landlords on behalf of groups of tenants, as well as other fun things. Thank you.
Yeah, good afternoon. My name is Parker Winship. I'm a senior staff attorney, and I worked with Natalie in the Tenant Rights Coalition. And that's why I wanted you to go first. You always say it better than me.
Awesome. Thank you so very much for being here, for sharing this information. And as a reminder to everybody who may have just joined us, please feel free to introduce yourself in the chat just to let us know who you are, what organization you might be with, anything else you might want us to know, like your borough. But please put your questions into the chat, and then I'll ask them of our presenters at the right moment. Okay. Yeah, so maybe Adriana, you could get us started with the first slide.
I think that's actually the second slide. Do you mind going back one?
Thanks, Adriana. Yeah. So let's see, who's starting us off?
Okay. Yeah, so I'm starting off, I guess. If we could jump into the next slide, please. The overview of today. Excellent. Hi, good afternoon, y'all. Thank you for being with us on a Friday, especially when it's so nice out after how hellishly hot it was for the past couple of days. Just wanted to give you a quick overview of what today's presentation is going to be on. And just to make really clear, because since we first gave this presentation, I think it was last year, the good cause eviction law has come into effect. And good cause is a separate set of regulation from rent stabilization, which is what today's presentation is going to largely be about. So even if your apartment was never subject to rent stabilization, or if your apartment has been deregulated and is no longer rent stabilized, it may still be covered by the good cause eviction law. Now, Housing Court Answers did a great presentation on this back in May. The link is should be provided in the comments. What's it called? The presenter comments. I think we'll be sharing that in the chat momentarily. If you have any questions about good cause eviction law coverage, I strongly encourage you to go and check that training out first, because everything we're saying, it's kind of two tracks of protection, which may overlap. Today's presentation is going to be about first briefly talking about the Housing Stability and Tenant Protection Act of 2019, often abbreviated to the HSTPA. And though the HSTPA closed a lot of different ways that owners were able to deregulate buildings, there were some loopholes remaining for owners to try and bring their buildings and the apartments in them out of rent stabilization. So today's presentation is going to be on those remaining loopholes after the HSTPA. So substantial rehabilitation, demolition, Frankensteining, co-op and condo conversions, J51 and 421A, which we promise will explain what those are. We're not just leaving the numbers out there. And then kind of wrapping it up with final thoughts. A quick note, Frankensteining, it's a term that's used, Sam's going to cover it. It's no longer the law that owners can deregulate through Frankensteining, but that was a recent change. That was 2023. So we're still going to cover it because your rent history when you request it might contain some information or some indicia that the apartment was Frankenstein. So it's still relevant, even though it's not the law today in the very recent past.
Okay, so I'll cover this part, my favorite part, and we wanted to start off with this because this is probably the most important thing out there. So I've been doing legal work for many years, and the biggest lesson I've learned is that organizing gets the job done. So first and foremost, if you're a tenant living in New York City, organize, and then organize some more. And if you're out of ideas, just keep organizing. It's the greatest strength tenants have, which is their collective power. Doing legal work, I've learned that the law is very punitive and abusive, but tenants have the tenant's power is fierce and unstoppable. I've seen groups of tenants win in ways that the law simply doesn't allow for. So that is why I'm encouraging that first and foremost. In addition, in New York City, tenants have a right to organize. The law in New York City says that tenants have a right to meet in any common area of their building. So you don't have to fight alone, and you can form a tenant association, and the landlord can't retaliate against you for doing so. Of course, they may try, but there are avenues of relief if they do so. I would also recommend to reach out and work with your local tenant rights organizations to get assistance. There's a link there, which for those of you who'll be able to access the slides after, you'll be able to click on and get a list of organizations. So plug in with them because you can work not only with the larger tenant rights movement, which often fights for the same changes that affect us all, but also it can help you organize your own tenant associations. And then with regards to a lot of the things we're talking about, DHCR is a governing agency that was created to protect or unstabilized tenants. And it's a state agency, and a really important factor is that if you receive any notices from them is to respond, challenge, and don't ignore any of their notices. Equally as important, and one of the most common things that happens when tenants receive notices is do not self-evict. Only a judge in New York City can order a tenant evicted, and if you leave because you received a letter from their lawyer or the landlord, you are what's called self-evicting under the law. In addition, in our experience, we've seen really strongly worded letters even coming from lawyers of the landlords. So sometimes you're like, this guy wrote this thing. It seems like I have to leave by the 31st. No, you don't. Call 301, call Housing Court Answers, and get connected to a legal service provider to get some advice on how to handle the situation. With DHCR requests, another thing is that with DHCR, they very easily extend extend the deadlines. So you can always make a request to extend deadline, especially for really good reasons, such as you need time to seek counsel and get advice. Or you need time, let's say you're living in a large building, you need to talk to 500 of your neighbors, 21 days is unreasonable to try to get that done, right? So it's far easier to ask for more time than to reopen a DHCR decision that's already been made. And lastly, I have this little blindfolded referee on the bottom right of this slide, because that is kind of how I feel about DHCR. Whenever you're filing things with them, they, even though they're an agency that's supposed to protect or unstabilized tenants, they do not independently look into any information, even if they have access to it. So as tenants and advocates, you have to directly point them to information. They do not do any of their fact finding. Just to give you an example, like if you have a clear overcharge just by looking at the rent history of an apartment that's rent stabilized, they will put that paper away. So you really have to challenge it and show what in the rent history means that there might be some examples of fraud and present the arguments and facts in order for them to take it into consideration. Okay, thank you. Next slide.
So as mentioned, like just at the oh, there we go. Got the mic. So as mentioned, the Housing Stability and Tenant Protection Act of 2019 was a real watershed piece of legislation. It was there's a lot of work by a lot of wonderful people that went into getting this law passed, and I can't say enough to do it justice here. So I'll just say it was the biggest overhaul of housing law going back in decades, and it covered all sorts of tenancies. It covered rent stabilized. It changed some rules on rent control, those few units that still exist subject to it, as well as market rate tenancies. A couple quick overviews of the HSTPA, just like a couple bullet points worth noting, is that it changed the rules around preferential rents, making it where once a rent stabilized lease was given with a preferential rent, that preferential rent, which is a rent that's lower than the market rate or the legal regulated rate for a unit, would get locked in and stay for the duration of that person's tenancy. It also ended this practice called high rent vacancy deregulation, whereby if the landlord could get the unit's regulated rent up over a threshold, the unit would no longer be rent stabilized. That's now done. That's no longer an avenue to deregulation. Likewise, major capital improvements, MCI, were a way by which an owner or landlord could put a lot of work, sometimes only on paper, into a unit to raise the rent there, commensurate to the amount of repairs invested into the unit. That used to be an avenue to deregulate. Likewise, that's now no longer a way to deregulate a unit. While there is still a way that landlords can raise the rent with major capital improvements, MCIs, it's no longer going to be a way to make the apartment not rent stabilized. Housing Court Answers also has an excellent training on MCI. So if you see that start to pop up in your rent history, or if you get a notice saying that your rent's going to be increased because of an MCI, definitely come back, check the HCA website, look up the MCI training. It's worth a watch. So today's presentation is again on the post HSTPA means that the owner can use to try to deregulate a rent stabilized apartment and what can be done to challenge them. Today's presentation is current to today, as best we could make it. The law is always changing, always updating. So if you're watching it after today, definitely check with the community legal service provider, see if there's been any other updates. And yeah, next slide, please.
Okay, so the first form of deregulation I'm going to talk about is called substantial rehabilitation. So first, just to define what it is, basically it's when a landlord takes a building out of regulatory status, meaning it's no longer rent stabilized or rent regulated. The landlord can do this if they can prove that DHCR, to DHCR, that the building has been substantially deregulated. I have in the slide for you DHCR fact sheets on substantial rehabilitation, or you can also Google DHCR sub-rehab or substantial rehabilitation and look these fact sheets up. I also want to mention that DHCR's website has a lot of useful fact sheets that are really, really helpful in understanding your rights as a tenant living in a rent stabilized building. Next slide, please.
Oh, and also I just wanted to mention, Natalie, I put the links that were on the slide, I put them into the chat as well so people can save them.
Thank you so much, Sarah. It's really useful. Okay, so the next slide is what criteria must the landlord meet? So a lot of this is copied from the fact sheet, but I'll just quickly summarize without reading all of these things. But basically, the landlord must prove that at least 75% of the building's wide systems and apartment systems were replaced. And the systems are listed here. This is an update from just like a prior rule that said systems. Now the systems are clearly defined. So if it's not one of these things, it can't be seen as 75% of the systems. So usually 75% of the systems means that it's a good percentage of the building systems in this building. So it would be 75% of the list of here, presumably. Next slide, please. Additionally, the landlord has to replace all ceilings, flooring, place boards, wall surfaces in the common area that's in the hallways and the stairs, and replace ceilings, floor surfaces in your apartments. And if they're not replaced, they must be made new. And DHCR gets to make the determination as to whether they seem new enough to not be replaced. And there's this like exception to replacing systems, which is the landlord shows that a particular system has been recently installed or upgraded, or if it's structurally sound, it doesn't require replacement, or is for historical merit or aesthetic reasons, doesn't need to be replaced. So that's another exception. Other criteria that go ahead.
Sorry, just could you maybe give an example of what would be something that could be desirable or required by law due to aesthetic or historic merit, like I don't know, like a marble staircase or?
I'm not sure, but I have a feeling this is about like preserved historical buildings, probably. So just like you're not allowed to do codes, like change the facade of a building, for example, because it's, has a certain type of regulation on it. So that's probably an example. I'm sorry, I haven't actually faced that. I don't know if others on the team know an example, but that's the one that I could think of most immediately, if that helps.
Thank you.
Although marble staircase sounds really nice. Okay, two. The other thing that the landlord must do, comply with, is that the rehabilitation must have taken place when the building was substantially or seriously deteriorating. And there's a new exception to that rule, is when a space was converted from non-residential to residential use, that it does not have to be substantially deteriorated. So if it's like office building that was converted to apartment building, it does not need to be proved to have been substantially deteriorated. Another rule is all systems, this is number 3, must comply with the building codes requirements. Owners must submit copies of the certificate of occupancy before and after the rehabilitation. And the certificate of occupancy, often talked about with its acronym COV, is basically just like something they had to file with the city to prove that this is an apartment that's livable. It has a bathroom, it has a kitchen, it is legally under the codes. So they actually now have to submit that. And then the fourth thing is that, and this is a rule that started for after January 1st of 2024, substantial rehabilitation performed before that date must seek approval from DHCR within 1 year of completion. So
sub rehab performed after that date.
Yes, sorry. Yeah, thank you. And another, I wrote terrible rule because I'm not a fan of this, but if an occupied unit was not rehabilitated, but the rest of the building received some rehabilitation. So let's say you're living in an 8-unit building, you're living in an apartment, it wasn't rehabbed, and then that unit remains rent stabilized, and the rest of the building can be approved for rent stabilization while you live there. But then the second you leave, even though your apartment wasn't rehabbed, it will come out of the rent stabilization code because the rest of the building was approved. So that's a rule we do not like, but is now in effect. Okay, other things. That again, we are still on the subject of what criteria the landlord must meet. So the landlord is required to submit documents to DHCR for work that was completed after November of 2023. They need to submit records demonstrating the scope of the work actually performed. When I say scope of the work, I mean, okay, we replaced all the plumbing systems, we did all the ceilings, right? So they have to describe, the scope means describe the work. And what is included in the records is itemized description of replacement and installation, copies of approval of the building plans, architect, general contracting statements, contractors' work performed, appropriate government approvals, photographs of the conditions beforehand and after of the work that was performed. The owner must also submit proof of payment. If the work was completed before November 2023, excuse me, DHCR may be more lenient towards the landlord with documentation requirements. So this is a new requirement with regards to the strict rules, but now it's, but prior to November 2023, it was a little more lenient.
So,
Go ahead.
sorry, just to jump in here, something that some tenants associations were facing in my neighborhood was that a landlord would file a sub rehab, like an application with DHCR to deregulate the whole building, and they say, well, I basically redid this building back in the 80s, and I didn't think about it at the time, but now I want to deregulate the whole building based on that work I did years and years ago. So are you saying that this kind of maneuver is still allowed under the new laws, or is that no longer allowed?
My understanding is for them to do it now, the work must have, okay, so sorry, this is confusing, I guess, the way I wrote it. So if the work was completed before November 2024, DHCR is going to be lenient on that. No, sorry, 2023. And if it was after, if the work was completed after November 2023, they have to submit the sub rehab within 1 year of completion of the work. So the landlord would still be able to do it in your example of like work they did in 1980, and DHCR may be lenient towards them.
So I guess, yeah, it's one of those things where, yeah, the tenants are going to have to do a lot of the legwork themselves. They can't just assume that DHCR is going to block things. Like they have to work together to collect information and yeah.
Yeah, and I'm going to talk about what you can do about it next. Yeah. So let me just talk about a few more things, and I'm going to tell you about what you could do to fight this. 2 more slides, because that's the juice. Okay, so exceptions to these rules is if the landlord was convicted of arson with the purpose of creating vacancies. So if they, made a building go on fire to show that it's deteriorated, and they wouldn't, and if they have an actual conviction, a criminal conviction, they wouldn't be able to say that it was sub rehab. It wouldn't be able to get a sub rehab determination, or if there's a finding of harassment either in court, in housing court, or with DHCR. So, harassment is defined as anything the landlord does to violate your rights or deny you your rights as a rent stabilized tenant. It's not like the typical, what we think of the meaning of that term. It's more broad. So lying about what your rent should be, denying you repairs, having leaks and not repairing them and patching them, this all considered a form of harassment under New York City law. So, try to raise those defenses in housing court or file a DHCR claims for harassment is another way that you can fight sub rehab. Other exceptions. So if the apartment was occupied during the rehabilitation work, the apartment remains rent stabilized, but the next tenant, if there's a sub rehab determination, it comes out of the rent stabilization status. If it's a vacate apartment, meaning you were vacated due to a fire, or maybe it's apartment isn't livable due to like violating certain codes, you should file something with DHCR that you're vacating, or if you have a temporary relocation, you should file something with DHCR that you should file a rent reduction order, and that would mean that while you're not living there, while you're under this agreement, your rent would be $1. And it would preserve your tenancy. This is really important to do. And then when the building is completed, when the work is completed, the vacated apartments remain rent stabilized when they move back. If the vacated apartment choose not to move back or do not come back, that apartment comes out of the rent stabilization code if the sub rehab is approved by DHCR. Okay, moving on. What are the steps to fight this? And like, how does it all work, right? So the first thing that happens is the owner applies for a they may apply for an advisory that is recommended to them to try to seek prior approval on the sub rehab. And the landlord files this application to determine if it can be exempt from rent stabilization law. I put the name of the form in case you're curious what it looks like. And what happens is tenants receive a notice saying that the landlord is considering taking the building out of rent stabilization. You can file a response within 20 days from the date appearing at the bottom of that notice to say, we reject this, we object this. We shouldn't be, the landlord never did any work. I haven't seen them do any construction, do anything. Like, just get an extension if you think that you have the capacity to like organize with your neighbors and try to come up with more facts. But it's really important to respond to these notices to get more time. And the step 3 would be that the tenant and landlord may receive several like requests for additional information and evidence. Usually this is just back and forth with the landlord. The tenants aren't always receiving copies of these back and forths. Often, if you do receive a notice like this from DHCR, you often have 21 days to respond, but you do have a right to request an extension, especially because by the time you receive the notice saying you have 21 days, it's usually about 14 days left, because by the time it hits your mailbox. And always request extensions to get you more meaningful, like to be more meaningfully able to respond. The next slide, I wanted to show you guys what it looks like. So these are, typically it has DHCR at the top. On the right-hand side, you have your docket number, has your name, and sort of like this is the thing that shows you that the landlord has began this case. Okay, next steps. Next slide, thank you. The 4th step is the tenant or the landlord receives an order. So that means, this usually takes a few years or less time if nobody responds and DHCR just believes everything the landlord says. And then the tenant receives order and determination that the building is or isn't going to be sub-rehabbed. DHCR could reject the landlord's filing. And if they rejected, the landlord can still, if they did do work and they're, have paperwork to prove it, they can still file for individual apartment or MCI increases, but they have to apply for those things affirmatively. They still have to put in the paperwork for a different type of application once the sub rehab is rejected. However, if the sub rehab is allowed and there's an order allowing the substantial rehabilitation, that means that the units affected in the determination come out of the rent stabilization code. If you're a tenant living in this building and the first thing you're seeing from DHCR is this order determining that you're sub-rehab, chances are when the landlord did that step 1 and filled out the paperwork, they claimed your apartment was vacant. We've seen this before. So it's really important to file something with DHCR to let them know this is fraud. You were living there, and they need to undo the decision and give you time to respond. And what you would be doing is step 6. You'd be filing requesting a redetermination and pointing out that you do live there. And I'll explain how you're going to do all that in the next few slides.
We did have a question. Is the RS3 form new?
Not to my knowledge, but can I respond after my section in writing? Okay, great. Thank you. Sure. I'll respond in the chat. Sure. Okay, so yeah, but yeah, like even after you, sorry, can you go back to the previous slide? So sorry, I'm almost done. So step 5, even after you receive the order determination, the tenants can challenge it through what's called a PAR, or petition to administrative review. You usually have to do this within 35 days of the decision, and there are rarely, I don't believe they allow extensions on these, but you can supplement whatever you send. So send something, supplement it while the PAR gets its own docket number, becomes its own case. But it's important that you cannot present any new facts at this stage. The PAR, at this point, only everything that's already been presented in the case can be presented in the petition to administrative review. So no new facts. If you are looking at new facts that are like fraud or the landlord lying and you have proof of that, what you want to file is a request for redetermination, which is a very different thing that does allow you to present new information that hasn't been presented in the case before. Sorry, you have questions? No? Okay.
Yeah. No, I think other than that, I need to look at the other questions and we'll get
Okay.
yeah.
Okay, great. So then, yeah, so now next slide, please. So yeah, how to challenge the sub rehab. So I think the most important thing is to respond and respond timely. Challenge, don't ignore the notices. Get more time all the time. These cases can take years, and sometimes and time is really on your side. Request 90-day extensions to respond after receiving notices of the landlord filing. If an order is issued for sub rehab, request the records. Request through the what's called the Rec 1 form. You can see the full file of everything the landlord filed. And if you request the extension to the to respond to the determination with the request for full records, the clock to respond starts only once you receive the records. So sometimes DHCR takes like a few weeks or sometimes months to give you the full records of the file of everything the landlord submitted. And, sometimes it could be months. So if they take 5 months to send you something, the 35-day clock to file a petition to administratively review doesn't start until you get all those records, and then you're able to more properly respond to them. Review if the landlord applied for an advisory opinion and see if DHCR has already given them like prior temporary approval so that you could see where that came from and have better understanding. I also want to you can always see the status of the case. So as we showed you in that DHCR notice on the top right, it's always going to have the docket number. If you file a petition to administrative review, it has its own docket number, and you can go on this DHCR website. I have the link here, and you could check where it's at. Is it being seen by someone? Is it under, initial processing, means it's somebody sitting on somebody's desk? Is it actively being processed, or is it in its final stage? At any point until there's a determination, you can respond and supplement. You do not have to wait for DHCR to request anything. You can always add more to this case until there's a final order. And most importantly, as I said in the beginning of this presentation, work with your neighbors. If one doesn't already exist, form a tenant association. Oh yeah, and with the case status, you can also easily Google it by Googling DHCR case status, and it pulls up the website where you could look that up. Next slide, please. So how to in the substance of how you're responding, like I want to talk about what you're going to write about. So you don't need all the facts in the initial response. You can, in your initial response and supplement responses, always write the words, "I reserve the right to supplement filings," although you still have that right. You can, and I highly recommend you do this every single time, whether it comes to rent reduction orders or sub rehab, request the DHCR independently inspect the systems of the building. Have them come take a look at the ceiling, floor, and plumbing. And although this doesn't affect the law, tenants can always write their gentrification stories, which is their experiences with the construction, rehabilitation, their or lack thereof, right? How does this affect your building, your neighbors, your community at large? What effect has this alleged or not real work affected you and your neighbors? And I think that's really important because the people who are reading these cases are human beings, and then there was a lot of law and facts behind them. It's really important to present like the struggle of what it's like living through these decisions that DHCR does or doesn't allow. And like I mentioned previously, file a harassment with DHCR if you can. If you're in court, if you are being harassed, make sure that you use that as a defense in your cases, because if you could get a finding of harassment, your apartment or building cannot be sub-rehabbed. And also, I did mention this before, but if you're a vacated tenant or you have a relocation agreement with the landlord, or even if you don't have an agreement and the landlord has asked you to temporarily relocate, while you're not in possession of your apartment, file a rent reduction order, and your rent will be $1 while you're away, and that will preserve your rights to the unit. Okay, next slide, please. Okay, we're almost done with the section. Sorry, that's lots of fun, but almost done. So yeah, gather your evidence to challenge. like periodically, every few months, file this request for records, see if there's any back and forth with the landlord. Look at when you get the records, look at the spending. Do the numbers add up? Do the math. Is what they're saying they did proved by receipts, even if it's not like the strict standard that I mentioned in an earlier slide of documentation proof. Does the information match? It's okay to point it out, even if DHCR is going to be more lenient. Confirm the itemized lists are on there. The dates of the work matches the permits in the Department of Building websites. Write about how many units were vacated during the rehab and not vacated. And then look at study the Department of Buildings website and the HPD violations during and after the rehabilitation work. And I'm going to give some examples of that. So for instance, let's say they're saying that they redid the roof. And you get a sub rehab that they're, you know that they did roof work. You get a sub rehab. The landlord applied for sub rehab, and you go on HPD website and you see that many of your top floor neighbors have been calling 311 because they continue to experience leaks in their apartment. You want to point that out to DHCR. They are not going to independently look at anything. They have blindfolds on, as I described in earlier. An example with Department of Buildings, let's say one of the systems they claim to replace is the elevator, and tenants continue to live without working elevator. It's really important to go on the DOB website and point out to DHCR any violations for a non-working elevator or even complaints. And both of these things also just a friendly reminder to always call 311 and report all your violations. You can call, text, or go on the 311 website to report these things, because you never know when this might be useful. You never know when you might need to show DHCR that the elevator wasn't working or that your, apartment has a leak. What it does is it preserves you're not complaining about the landlord or getting the landlord in trouble. What you're doing is preserving information about what you're living with. And it is their fault you have a leak in your apartment. Or that the elevator is not working, and you're not doing anything wrong by reporting it. In fact, it is your right to do so, and anything the landlord does against you to retaliate for calling 311 is a form of harassment. Okay, last slide about challenging, and then I will take a water break. So just continued evidence. What else? Chart out the systems, like try to write it out, like, okay, 75%, what does that look like? What was done, what wasn't done? Study your hallways, go to your neighbors' apartments. You can also do a FOIL, that's called the Freedom of Information Act, on the DOB website. I put the link there. And you could see what permit information, so for the permits they have on DOB, it lacks a lot of information, and you could file FOILs to see even more information. Filing these FOILs and waiting to receive them takes a lot more time than the Rec 1 or the request for records with DHCR. So you can always use that as a reason to file for more extensions. Like, I cannot answer this request because I am waiting for DOB FOIL. Here's a copy of my request. The DOB FOILs sometimes take months. You can also email the tenant advocate of the DOB, which is a person that can answer your questions as a tenant. DOB also has after hours sessions for tenants and landlords. It's the first and third Tuesday of every month. I put a website link where you could look at that, or just Google after hours sessions of DOB, and you could go and talk to them. What is this permit? When was the period? How much did the landlord pay? What was the company they were using? Because a lot of the stuff on the DOB website is just not legible. And to the average person, including myself, as someone who looks at it all the time. And research their companies. You could look up, are they licensed? What is their corporation status? Are they functioning under a corporation that isn't doing their taxes or doesn't exist? I put in some friendly links there where you could look up the web through the Department of State. You can look up the corporation existence. You could look up licenses of specialized workers. Yeah, so that's sub rehab. Thank you. Sorry, on mute.
Apologies. So yeah, there are questions about sub rehab. Oh, and I tried to put some of those links into the chat, but we did have a question from somebody. Some landlords are managing companies as well. And then, if the landlord is also the corporation that is doing the actual work and cost of construction, um, who who is able to oversee and determine whether the actual work and cost of construction is legitimate or not? I mean, is a land is a if a landlord is both a property owner and a management company, are they allowed to basically contract out to themselves to do this work?
Um, I think that would, I'm not sure if this is like a real circumstance, but usually landlords in New York City tend to be a corporation, an entity. It's rare that we see landlords who are a human being anymore. And most buildings in New York City, especially the ones that are rent stabilized, are now owned by groups of landlords. And often they hire managing agents. So the landlord lives in London and they have like some guy named Joe running the building who works for another LLC. And often tenants think that LLC is their landlord, but it's actually a managing company that can be easily fired by the owner. And if that LLC, the managing agent, does the construction, I mean, if they're doing a new elevator, they better have the permits. Check the DOB website. If they're doing, you're putting in walls, ceilings, flooring in the building or in apartments, you need a permit for that. So it depends. Check the contractors. But if you're seeing the landlord's LLC or their managing agent LLC doing this work, please point that out to DHCR in your supplement filings, being like, this is the same owner, or that's their cousin. I know that's their cousin because I went to their barbecue last year. You know, like you got to point these things out to them. Again, they're not going to independently look for any facts. So any facts you have just strengthens your applications and opens up more queries that they should be looking into. But don't expect them to think do the thinking for them. Point it out. They have blindfolds on.
Right. Yeah, and a lot of people have put comments into the chat regarding the fact that DHCR is not looking into stuff. There, with one more question, is there a time for, so the harassment case, the harassment finding making the sub rehab impossible. Is there a time frame or time limit on that? Like if sorry, go ahead.
No, but if you file if you know that your landlord's doing a sub rehab and you file a harassment claim, the sub rehab decision cannot be made. But again, they have blindfolders on. If you do not point out to them that you filed a harassment claim, they are going to not notice it. So DHCR, even though you're sending multiple applications to the same agency, you have to point them out to each other. So you have to say, we filed a harassment claim. Until that's decided, we ask that you put the sub rehab on hold.
Thank you. I think we can move to the next section.
All right, so next up, I'm going to be discussing demolition. As before, I will address any and all questions. We are monitoring the chat. I'll address them when we get to the end of the section. So be assured if you have a question, we're aware. Um, Demolition. The demolition, as defined within the updated, like the newest guidance, is defined as the removal of the entire building, including the foundation. Now, the reason I'm providing that definition is that is something that's changed over time. There used to be a practice of partial demolition, quote unquote, where a landlord would even demolish a single apartment or would remove part of a building while leaving the foundation. And DHCR and the relevant state agencies finally decided to put the kibosh on that in guidance that was published, I believe, in Operational Bulletin 2023-2, which I'll discuss in a moment. Demolition is a process that the landlord initiates or the owner initiates to ask multiple state agencies for permission to demolish the building and in the process to end the tenancies of any rent stabilized or rent controlled tenants who are at that building. So demolition is a way that owners can stop renewing rent stabilized leases and a way that owners can try to either relocate or evict tenants. Today's discussion is solely going to be on rent stabilization. If you're one of the 2000 and change people who has a rent controlled apartment, there are different rules for rent control demolition. It's a more onerous burden for the owners, but because it's such a niche area, if you have a rent controlled apartment and you get any notice that the owner is attempting to demolish the building, reach out to HCA, reach out to a tenant legal service provider, because you have unique rights that are a little too detailed for me to go into today. Everything I'm going to be covering today, well, not everything, but a lot of what I'm covering today you can also find information on within DHCR fact sheet number 11, which is a two-page PDF that explains the basics of demolition, and DHCR's Operational Bulletin 2023-2. Now, the operational bulletins are the more lengthy guidance that DHCR gives out and does involve a bit of the legalese, but it lays out kind of the entire process as DHCR sees it. Now, in order to demolish a building, a landlord has to meet two criteria for DHCR. Now, this is not just the criteria for other agencies like Department of Buildings, there's other rules. But for DHCR, they'll give permission for an owner to demolish if they satisfy two things. First, that the plans to demolish the building have already been approved by the Department of Buildings. Hereinafter, I'm going to call them just DOB, but that's Department of Buildings. And the owner has to show that they have enough money to complete the undertaking. That's the term that means both to pay for the entire demolition, as well as to pay for any relocation expenses, stipends, things of that nature. I've seen some cases and some decisions kind of pushing back and forth on whether complete the undertaking also means whatever new thing they plan to do with the building. To date, I haven't seen DH or the location that the building's in. To date, I haven't seen DHCR drill down too deeply on that, but that's always subject to change. Demolition has strict rules around timing. Rent stabilized leases have rules about when they can be ended and when termination notices have to be sent. And during the process of a demolition application, even as that's pending, the owner has to cleave to these strict timing rules. And if DHCR does provide permission, like does approve the demolition, that does not mean tenants are immediately evicted. Instead, if DHCR says that this building can be demolished, then the owner has permission to no longer renew leases. DHCR tells the owner they have a choice, and it's the owner's choice to do one of three things. Option one is to relocate any existing rent stabilized tenants at the owner's expense to another rent stabilized apartment that is closely proximate, so nearby their current apartment, and that the rent for that unit has to be lower or the same as their current rent. So option one, the owner will give you another apartment to move into that's at the same rent, and that apartment will be near. Option two, the owner can relocate existing tenants at owner's expense to another closely proximate apartment at a higher rent rate than your current rent stabilized apartment, but the owner has to pay the difference. So if option two, if the owner moves you to another apartment and that rent is higher, the owner has to pay the difference between the rent for 6 years, 72 months. So option one, the owner moves you at their expense to another apartment, same rent or lower. Option two, more expensive apartment, but they'll pay the difference. Option three is the owner pays out a lump sum to the tenants that's based on a difference between market rate apartments and their current apartment, calculated also based off the number of rooms in their apartment, multiplied by 72 months. So 6 years worth of money. Now, that third option is the easiest for owners to do because they don't have to find another vacant apartment that's rent stabilized. It's also the most expensive option. Typically, these lump sums, if you have a rent stabilized apartment with a low rent, that lump sum is possibly going to be in the low to mid six figures, which means this stipend can be sizable and therefore making sure that you're staying within what the law allows on this and that you're following up with the process is going to be important. Now, how a demolition application works. First, as mentioned, since DHCR needs to see approval from Department of Buildings, the owner starts by filing the demolition plans with the Department of Buildings, not DHCR. They file a packet called a PW1, a plan/work application, that is a very general form. It describes a lot of things that an owner can do with a building, one of which is demolition. That application has several sections in it. It's several pages long. I believe it's section 26, one of the last sections on it, contains information about which apartments in the building are currently occupied, whether they're rent stabilized, rent controlled, or market rate, and what the plan will be during the whatever the plan the PW1 is for, in this case demolition, what the plan will be for those occupied units. Like, are there going to be occupied units during this process? In the case of a demolition, no, like people shouldn't be living there while they're tearing the building down, but they have to say whether there are currently rent stabilized tenants in the building. If the Department of Buildings approves the PW1, that's where the owner can then turn around, go to DHCR, and file an application with them asking for permission to stop renewing leases and to evict any tenants who remain after DHCR's approval. That application, the form RA54, the owner sends to DHCR, and the owner has to include within it those two things I said before. The Department of Buildings has approved the plan and that they have enough money to complete the undertaking. They have to send that to DHCR with their RA54 paperwork. Once DHCR gets it, DHCR turns around and notifies all of the tenants. That's usually the first time that tenants are going to hear that any of this has begun. Like the DOB plans don't get sent to the tenants. The initial paperwork isn't sent to them. Instead, the tenants find out when DHCR notifies them that their owner has filed this application. DHCR sends all the tenants in the building this packet with all the information that the owner sent them, and say you have 20 days to respond. Just 20 days. That packet will have the application's docket number. There's a separate docket number for each apartment. It'll be important that you keep track of that docket number and that you hold on to the packet and that you respond promptly. As said, 20 days is not a lot of time to respond, but do definitely send something in, because if there's no response at all, DHCR can do, as Natalie's indicated, they can just read the landlord's paperwork, put on the blindfold, this is all we see, or the owner's paperwork, this is all we see, fine, you're granted permission to demolish. Whereas as soon as the tenants respond, as soon as you file anything back with your docket number on it, DHCR will then begin this process of seeking more information. DHCR will ask both the owners and the tenants for information, kind of back and forth, continuing until they feel like they're ready to make a decision. And DHCR might decide to even set a hearing if there's some sort of factual issue that DHCR thinks that a hearing would be suitable for, but it's not necessary. Um, while that application is pending, the owner does not have to issue renewal leases. They can say, we're not going to renew your lease because we filed an application to demolish the building. That does not mean you're not a tenant. The protections of rent stabilization are statutory. You have a statutory tenancy that is enshrined within the rent stabilization law. So you are still a tenant even without a lease. I've seen a lot of people who is like in this demolition process, they start to hear things from their neighbors or management that's saying, well, your lease is up, you've got to move. That is not the case. If you move, you can wind up forfeiting your rights here. And as mentioned before, six-figure settlements might be on the table. So you don't want to move. You are still a tenant even during the pendency of this application, even if your lease is expired. While that application is pending, instead of renewing your lease, the owner instead has to serve termination notices or notices that they're not going to renew your lease, and they have to do so within a window period. That's 90 days to 150 days before the expiration of your lease. The owner has to serve you with paperwork saying we are not renewing your lease at this time because we filed this demolition application. If they file it too late or if they serve it on you too soon, then it's off. And in that case, the owner is by law has to give you a renewal lease if they miss the window, and then they have to wait another 1 to 2 years to even restart trying to end your lease. So those are the strict timing windows I mentioned. After there's been some back and forth, usually DHCR will ask the owner to respond to whatever the tenants put in their response, then they'll ask the tenants to respond to whatever the owner said, and the back and forth continues for a while. Eventually, DHCR issues a decision. Now, eventually can be as I'll mention soon, it can be a years-long process, but eventually they'll make a decision. If the owner's application to demolish the building is denied, then the owner must immediately issue new leases to everyone. The notice that they said that they gave saying we're not going to renew your lease, that's off. They have to give you a new lease. But if the owner's application to demolish is granted, then DHCR will say when the owner is allowed to relocate tenants by and or when they have to give them the moving stipend. So DHCR will decide like, okay, we're going to approve the demolition, but here's how long things will have to take before you're allowed to start having tenants move. A decision from DHCR can be appealed. It can be appealed internally with a petition for administrative review, which is where you basically are telling DHCR, hey, here were all the facts, but you misapplied the law. Um, a, a denied petition for administrative review can be appealed in court. Each level of appeal, however, is harder because at each stage you're no longer asking for new information. You're trying to show how the people who had this information misapplied the law. Now, lastly, once or if an application is granted, um, the deadline that DHCR provides for people to either move, be relocated, or accept buyouts by, um, that's not the same thing as an eviction warrant. Like if you stay past the deadline within the DHCR order, the owner still has to file an eviction case, a holdover case, and start that entire process. However, because DHCR has already made a decision that you can be evicted, that process is one that someone is not likely to win. And the way that the DHCR, like the way that these buyouts are structured, or the way that the moving stipends can be structured, if you stay past the deadline that DHCR sets, um, the owner doesn't have to pay you the full amount anymore. Each month that you remain in possession takes out a chunk of the amount of money that the owner has to pay. So once DHCR is issued an order, if it's not appealed, and if DHCR doesn't stay the move out dates, staying past the move out dates can have strong adverse financial impact, even though they still have to start a holdover court case. So that's kind of the process of eviction. Now, challenging the application. Once you get the owner's RA54 that includes the PW1 and the plans that were approved by DOB, read those closely. Some of the sections, as I mentioned before, section 26 in the DOB plans, lay out details about who's in the building, how many people, how many of the apartments are rent stabilized, what's going to happen to them during the course of it. If the owner lies on this application, misrepresents how many tenants are in the building, which tenants are going to be relocated, or any information around the building. For example, if the owner says that there is no asbestos in the building and they don't need to get a Department of Environmental Protection asbestos plan, but if the building was built in the 1920s, that's probably not true, or at least it's something you might want to look into. So these little details within the PW1, each of these sworn declarations, read them carefully, see if there's any misrepresentation, because misrepresentation to DOB brought up to DHCR can have the whole thing get kicked back to DOB and be grounds to deny the demolition. Likewise, check that the PW1 specifies this is a full demolition, as before, the removal of the entire building, including the foundation, also called dirt to sky. If they're leaving a partial foundation, or if they've applied for some sort of variance to retain part of the foundation, for example, because in New York City, with buildings being built so close together, sometimes the structural engineers will not approve a full removal of the foundation because of the support that's needed to keep the other buildings up. If that's not a full demolition, if DOB either didn't approve the variance or if that variance was not previously raised to DHCR, that might not be a full demolition. These are things to raise with DHCR because the application that the owner's going to put in is going to be, oh yeah, we're doing a full demolition. It's already a done deal. We don't need to do anything more. But read close because that might not be true within even the paperwork that they file. Likewise, investigate through the application. Did this plan already get approved? Is it on the DOB website? You can look up every plan through either the DOB's old BIS system or the new DOB Now system. Is that plan there? Is it approved? Is all the paperwork there? Are the engineering firms and construction firms that signed off on the plan legit? Is this self-dealing? Is the management company also calling itself one of the contractors for it? Is that something that might be worth raising a red flag to DHCR? If you can't find any information on the DOB site, if you have questions about it, reach out to the Office of the Tenant Advocate. And the previous sub-rehab section had links for corporation searches that I think Sarah shared. Now, after reviewing the application, now, as I said, 20 days isn't enough to do everything. So probably what you'll want to do is ask for more time. Similar with sub-rehab, as soon as you get notice that this application has been filed, send in a response. Use your docket number for your individual apartment and say, we need more time to respond. We want 90 days to start. And file one of those Rec 1 forms. Ask for the entire file because maybe in the month since the owner first sent in the application and you got word of it, it might have been that they've tried to supplement the application in the meantime. And filing the Rec 1 asking for more information is also grounds to ask for more time. You can provide DHCR with the Rec 1 in your response saying, hey, we need more time to answer, and we're asking you for the full file, so can you give us the full file and time to answer or respond? I'm using the term answer because that tends to be how lawyers refer to things, but it's not that formal. Once you've had time to review everything, in your full-on response, put out everything. Throw in all the things that seem wrong, inconsistent within the application. Include your narrative. If there's been harassment, that can be grounds to deny it. Repeated buyout offers or uncorrected housing violations, things to try and get you to leave, that can be harassment. And as Natalie said, reserve the right to supplement your application with additional or your response with additional information. Um, yeah, and then also reach out to community legal service providers, housing court answers, the various resources that they can point you to. You might be able to get assistance, people who can check things like is the deed on the building actually registered to the owner? Is there a mortgage? Is there some sort of covenant? I recently saw a case where a mortgage had a covenant not to demolish the building within it that when they'd refinanced their mortgage, they said they wouldn't demolish the building. Then they turned around and tried to demolish the building, which was just the kind of inconsistency that DHCR then drilled down on and asked for more information about. As someone mentioned in the chat, like no one has time for all of this. A tenants association is going to be helpful here. Like having some neighbors who can help with the lift, especially if someone knows someone in banking or finance who can look at like if there's any regulatory agreements on the building, or if someone knows a lawyer who could look over the owner's application, that sort of thing. Like many hands make light the work. Now, as mentioned before, DHCR doesn't always get everything to the tenants at the right time. It can be that applications get supplemented and the tenants never find out about it. So file that Rec 1, ask for the full file, and ask for it often. In my practice, I generally try and file a Rec 1 every 3 months at minimum. And it's just kind of staggering them out, and we get in these big tranches of documents. And every time there's something new in there that DHCR hadn't sent us when they first received it. Once the application is under review, DHCR is going to reach out to both you and the owners, or the tenants and the owners asking for more information. DHCR can hold a hearing. They don't have to. Respond to everything, even if it's just a request for more time. If they send you a request for more information, you need more time to figure it out, say that. Always include language reserving the right to supplement with more information. Again, you have that right. It's always best to assert it, to make it really clear, to give more reasons that if for some reason someone screws up in the process, you have grounds to file an appeal. As mentioned, the owner can send the notice that they're not going to renew leases. They have to do it within that 90 to 150 day window. If you don't have a current lease when the application starts, or if they miss that window and your lease expires, that's grounds for DHCR to deny the application. Like if they are trying to file an request saying, give us permission not to renew a lease, if they didn't have a lease with you to begin with, or if they've been denying you leases or playing games with leases, that can be a reason for DHCR to say, no, never mind. This is foul play. We're not going to approve a demolition application until you've given them a lease and complied with the other provisions of the rent stabilization law. As with sub-rehab, you can check the status of a demolition case using this case status inquiry website, where you type in the docket number and it'll tell you what the status of the application is. It might be under review. Even if it's in final review is a term that I think DHCR uses fairly loosely. I've seen cases, demolition cases in final review for years without a final decision. So final review is far from final in my experience. Now, as mentioned, demolition can take years. The application itself can take 2, 3, 4 years until DHCR is satisfied that everything is being done above board or is satisfied that everything's not being done above board. The petition for administrative review can take another couple of years. If there's a court case on it, that itself can also take years. And time is on your side as a tenant. Like New York real estate with construction tends to be a very fast-moving process. I've heard a lot of adversaries I've been across the table with complain that if this gets dragged out any longer, they won't be able to afford to do it. And that type of, yeah, exactly. But that can be the um, time is on your side. That said, if you're getting tired, and sometimes I've seen tenants who want to like end the uncertainty, don't self-evict. Like as mentioned before, there are potentially six-figure buyouts on the table here. Like even if the owner quote unquote wins. If you leave the apartment or just agree to leave without something firm and in writing, you can lose everything. Like you can lose the right to come back to the unit, and you can lose the right to any sort of money for it. So if you're going to use a sort of out-of-court negotiation around a settlement of a demolition case, contact a legal service provider or get your own lawyer. Like it might be an instance where they like if it's going to be a significant buyout, you can possibly afford one. So, like, it's an instance where you can't afford to do that without help. A final decision, as mentioned, can be appealed, petition for administrative review, court cases, court appeals, then the Court of Appeals. You can go all the way up to, who knows, you could take it all the way to the US Supreme Court in theory. Each level of appeal gets harder. So, in general, try and get as much information in as possible and try and win on the original procedure. Lastly, as mentioned, tenants cannot be evicted from a demolition case by a marshal until after the DHCR proceeding is over and after a housing court case is done. So, like, the marshal can't come until way down the line, but if you're remaining after the final order from DHCR provides, and there's been no stay from appeals, you are potentially going to be losing out on the relocation expenses and or that stipend, which can be a significant loss. Again, it can be six figures. So you want to make sure that you're reading the DHCR orders, and if you're not appealing, do the cost benefit analysis there. All right. So that's demolition.
We've
Questions?
got
I'm
a few
seeing some stuff.
questions from the
Yeah.
chat.
Yeah, let's do this.
So coming back to the relocation scenarios,
Mhm.
is there a requirement that the apartments you get relocated to be the same size, same number
Um,
of
I,
bedrooms?
I don't, off the top of my head, I don't recall. I think they have to be similar apartments. I don't know if it has to be the exact same number of rooms.
Huh.
Let
Wow.
me, yeah, that is a good question.
And yeah, and knowing whether the room sizes will be the same. There's so much variety in New York City about sizes of
Mhm.
rooms.
Mhm.
Um,
As mentioned before, I think in my experience, what I've seen is owners tend to try and use the third option because it's the simplest for them. And since there's so many different agencies that are potentially involved in this, they like the flat stipend tends to be what I've seen more of. But yeah, that might be
yeah.
answerable in the operational bulletin. That information might be there. I can check while I am while I am off and get back to you if there's a simple answer.
Awesome. So there were two questions that had to do with conditions in the building and how that affects the demolition issue,
Mhm.
right? Like, is there a requirement that the building be in bad condition in order to allow them to move forward with the demolition process? Or could you theoretically have a beautiful building in great condition, but the landlord chooses to demolish? Is that allowed? Or what if the landlord has been refusing to do renovations or repairs for a long time, and now tells you, well, I want to demolish. So how did this factor into demolition?
Great question. I'll take those in two parts. The first one about like a building that's got nothing wrong with it, potentially pristine. The demolition guidance and the statutes that govern it don't care about the state of the building. If someone says, I want to demolish the building, what they have to be able to show is that they can do it and that the plan's been approved. So in theory, an owner could knock down a perfectly fine 50-unit building because they want to build a 55-unit building. And that wouldn't be a consideration, or that wouldn't be not allowed under the ruling, under the guidance. Um, to the second question of if the owner has let the building deteriorate, that would be harassment. Like if the owner is intentionally like letting everything get run down so that tenants will self-evict before the demolition, so that then they have to buy out or pay out fewer stipends or relocate fewer tenants. That is harassment, and harassment is grounds to deny a demolition application. It's an interesting catch-22 when you make that argument because the owner can then counter argue, well, the building's in such a bad shape that really would be good for the community to let the building be demolished and a new one be built. But it is usually pretty transparent when an owner lets a building deteriorate as a form of harassment to try and depopulate it. And DHCR is used to those types of harassment claims. So as Natalie mentioned before, you can file an affirmative harassment case and then connect them, like bring them to DHCR's attention because they won't find out about it otherwise. Or in the alternative, you can raise that you're being harassed in your response. And that's where kind of the power of tenant narratives explaining it to DHCR. If DHCR does find that the owner has been harassing tenants to drive them out, that can be grounds to deny the demolition application.
Yeah, thank you. Okay, lots of questions about this. So up to other outside things that people are bringing up are landmarking and rezoning,
Mm,
um, which in themselves are complicated.
yeah.
Um, yeah, and rezoning is something that might make demolition more. I mean, if a rezoning, just so people know, a rezoning is where they change what is allowable to be built on any given space, or piece of land, whether it's the type of thing that's on the land or the height, the density of what's built there. So I don't know if Parker, you can see those questions. Can a landlord demolish a building because of a rezoning? Does a landmark building, is that likely not to have a
Mm.
demolition?
Um, Because of rezoning. So as mentioned before, owners, essentially demolition's one of those broader areas where owners do have a fair bit of leeway under this law. Where if they want to demolish a perfectly good building, they can. And if the neighborhood's been rezoned, again, provided that they're also complying with all the other aspects of the law, they're not harassing tenants, they're waiting the full several years that the application takes. Like it's not by any means easy, but there's nothing in the law that says they can't do it. Um, if like in this case, if rezoning is like if there's a reason that they want an empty lot there because it's been rezoned, there's nothing within the statute that says they can't then ask to demolish after it's been rezoned. Again, all these other factors come into play. Like rarely do you see a case where everything being done, if they're trying to demolish a building to take advantage of a rezoning circumstance, then that's probably not the only kind of shady thing going on there. So it's not like it's not immediately dead letter, but rezoning sure is a they in theory could file an application to demolish if the area is rezoned. Yes. Landmark status. Um, I think I'm not sure off the top of my head. Again, I think that would come down to other legal protections that the lot would have. That would be something where if the building does have landmark status, that would be something to reach out to the agency that created that landmark status, and possibly a good time to loop in like a city council person, because the city council members within an area, especially an area that has landmark buildings can then put pressure on DHCR to like reach out and say like, hey, why are you going to allow this to go forward? And they can also kind of backwards looking put some pressure on DOB, being like, hey, well, we don't want this demolished. Can we make sure the application was done right? So, um, I don't know if I can say for sure whether it's more likely to not be demolished, but that's the type of area where bringing in community support would definitely be advisable.
Yeah, I mean, with anything that's in a landmarked area or historic district, the Landmarks Preservation Commission, they're supposed to ask for um, permission before even changing the facade, right? But
Yeah.
there was a famous or something that got a lot of attention in the press on Willoughby Avenue in Brooklyn, where there was a mansion, landmarked area, and they got approval from Department of Buildings to do demolition, but and they went ahead and demolished before they even got an answer from Landmarks. So all these different agencies, reaching out to the elected official can be really helpful.
Mhm.
Okay, so I see there are other parts, but or other thought questions, but I think maybe just in the interest of time, we might want to move on to the next
Mhm.
section.
I guess just the one I see Virginia's question, I want to just briefly address it. The question was if 85% of the building is gutted with tenants living there and the landlord lied to the Department of Buildings and said no rent stabilized tenants live there at all and no asbestos would be disturbed, is that effectively an unofficial demolition? So in that case, if the landlord's already commencing work in a building without ever having involved DHCR, that'd be a time where you would want to go to DHCR, like like head down, actually, just head down to the DHCR office on Hanson Place and like tell them this is what's going on. We have rent stabilized tenants living here. Likewise, reach out to the office of the tenant advocate at Department of Buildings and let them know, hey, there are tenants here in this building that is currently being demolished. That's not the demolition proceeding I'm speaking about is when DHCR starts an official proceeding. This is more an emergency circumstance where like Department of Buildings should be involved and DHCR should be made aware of what's going on. But that wouldn't be like an unofficial demolition case because if there is no DHCR proceeding, then there's been no demolition case for all of this to apply to. And y'all should be protected under the rent stabilization laws and the rights of New Yorkers to live free from a building that's being actively in a construction zone, temp protection plan, that sort of thing.
Thank you.
Oh, hey guys, this is me, Frankenstein. Okay, just to return to I think Parker's earlier note about whether or not this is now a way to deregulate apartments. It no longer is. Frankensteining as I'll explain further in a moment, was a way for landlords to restructure apartments in such a way that they could claim that the apartment was no longer the rent stabilized apartment that it had once been, and they were able to break it out of rent stabilization by resetting the rents. After the HSTPA changed, those apartments were no longer changed the law. Those apartments were no longer eligible to be lifted out of rent stabilization, but landlords could still reset the rents at market rate or above, if they could make out a claim that tenant agreed to that. All of this has changed. The reason why this is relevant is because maybe you are someone who has recently moved into an apartment that the landlord claims to have deregulated by Frankensteining it, and you may want to investigate those claims. Okay, next slide, please. Okay, so what is Frankensteining? So, as I touched on a bit, Frankensteining is when landlords change the layout of an apartment. By adding space, they have to add some value to the space, right? Usually by combining apartments together, right? Although courts in under this old regime sometimes would accept like making an apartment smaller, right? There were a lot of wacky factors that courts applied a lot of discretion to. But more or less it's altering an apartment, maybe making it bigger, maybe making it smaller. Now, as I'll go into further. Next slide, please. Okay, so right. For the reasons that I explained earlier, this was a tool that landlords used to break apartments out of rent stabilization, by resetting the rents. And the way that we see it in practice most often is when a landlord opens up like a basement, and creates like a duplex. That's a scenario that I've run across fairly frequently. They say, I've added space to this apartment. That's in addition to this housing accommodation. I should be able to reset the rent for this apartment entirely, etc. But all of that has changed. Um, they can't do that anymore, right? The law was changed in 2023, to protect tenants from landlords who want to raise this rents these ways. It's interesting because this was a big incentive for landlords to warehouse apartments, right? Because landlords, especially in large buildings, would wait until they could get two apartments next to one another, vacant, and then combine them, and then pull that large apartment out of rent stabilization, right? And rent it out for whatever they liked. Now the mechanism for recalculating the rent on an altered apartment has changed in ways that I think everybody here would agree is much fairer. So yeah, so going back to this old regime, again, if you're looking into your rent history, if your landlord is saying, oh, you're not subject to rent stabilization anymore, and you find out that they're claiming that because they've reconfigured the apartment, Frankensteined it, after 2023, it's important to know some of this information. Um, so since the fall of 2023, the state has disincentivized Frankensteining by setting the max rent limit of Frankenstein apartments, and the calculation is really interesting, I think. Next slide, please. So now, what's the most the landlord can charge for a Frankenstein apartment now? Now, the landlord has to look at the base rent, right? The set rent stabilized rent of whatever given apartment, they're reconfiguring, right? So a landlord can only raise the rent by the amount of square footage added to the rent stabilized apartment. So, for instance, if the rent regulated maximum for an apartment, sorry, is $1,000 a month for a 500 square foot apartment. That works out to $2 per square foot, right? So then if the landlord adds 100 square feet to the apartment, the landlord can charge $2 per square foot, allowing for a maximum increase of $200, right? So it practically regulates the apartment, in ways that are familiar from rent stabilization in general. So what if the landlord shrinks the apartment? Same thing, it's just, the converse, right? So same basic principle applies. Say the rent for the same 500 square foot apartment is $1,000. The landlord reduces the size of the apartment by 100 square feet. Since the apartment is $2 per square feet, the rent should be reduced by $200, right? So easy system for determining what the proper rent is here. Now, if a landlord combines an apartment with a non-stabilized apartment, the resulting apartment remains rent stabilized, right? Because you just cannot break a rent stabilized apartment out of rent stabilization this way anymore. And if you didn't create this rule, landlords would certainly take advantage of utterly destroying stabilized apartments in favor of creating larger market rate once again, which, this change in the law prevents. So. So, if the landlord got an apartment vacant through fraud, harassment, or evasion, right, the landlord cannot raise the rent on the newly Frankenstein apartment. This is a lot. I think we mentioned this during substantial rehab. We mentioned this during demolition. Harassment is a very good defense to landlords, loopholes in trying to remove an apartment from rent stabilization, right? And here, if you can prove that, like, say a scenario that I can think of, like a vacate order is placed on a building, right? That's usually when this kind of thing happens, right? Vacate order is placed on the building, the tenant is fighting to get back in, but then the landlord substantially alters their apartment, right, and wants to reset their rent, saying like, oh no, we added like X amount of square feet, so we'd like to raise the rent. That tenant can say no, like that was harassment. There was a vacate order. They failed to lift the vacate order while doing this work, and they did this specifically to deprive me of my rights. Like, great that they've given me a bigger apartment, but I don't have to pay this extra rent, right? So. So what's harassment? I think you guys touched on this a little bit earlier, but what it is an owner or an owner's agent's actions or their failures to act in a way that is intended to cause a lawful occupant to surrender their rights to their apartment or to surrender some right related to their lawful right to their apartment, right? And there's a long list of acts and omissions that create a presumption that a landlord has acted with the intent to deprive the tenant of their rights. Um, those acts can be things like, oh, here we go. Right. Repeatedly failing to fix serious violations in a timely manner, right? Locking a tenant out, removing their stuff, threatening words or behavior if the tenant refuses to leave, lying about the rent stabilized status of an apartment, saying like, for instance, you've got to get out of here. This apartment, you don't have any rights to this apartment. I'm not giving you a new lease. I want you out by the end of the month, that sort of thing. Making buyout offers without giving the tenant notice of certain rights, like that you have the right to reject the buyout offer and stay, that you have the right to seek counsel, that certain disclosures, like how much a similarly situated apartment in the same district might cost, right? Making buyout offers without, oh wait, I just said that. Performing work without receiving necessary permits from the city, right? Work without a permit, that kind of thing. So how would a landlord remove a tenant by fraud or evasion? So this is what I was talking about earlier, right? Failing to restore a tenant to their apartment after a vacate order and instead renting it to someone else, right? Convincing a tenant to move temporarily to perform work and then refusing to put the tenant back in after completing the work. both of those things would deprive the landlord of what, their right to an increase. Why is this important information to have? To know your rights in the future. Frankensteining apartment to increase rent, it is over, right? If you move into an apartment that's been Frankensteined after 2024, 2023, 2024, get your rent registration history from DHCR to see if the landlord has applied the correct amount to the rent, right? And this is interesting because I still don't think this is a well-known provision of rent stabilization law and code. Like I I feel like when discussing various scenarios with other attorneys, where some Frankensteining has occurred, I find that it's kind of rare that attorneys who have an interest in this law are familiar with this change. So much less you know everyone else. So where do I go? Sorry, I can't see this. If I think the landlord has increased the rent improperly after Frankensteining an apartment, yeah, reach out for advice. Go to Housing Court Answers, ask your city council member, assembly member, or state senator for help. Call 311 to ask for free advice from a legal services organization like mine or Natalie's or Parker's. And Parker's, call Met Council and ask about legal services and community-based tenant advocate organizations in your neighborhood. Does anybody have any questions about this?
Yes, we've got some questions.
Okay.
Uh, this one, ooh. What happens if an apartment was Frankenstein and deregulated pre-2019,
This
but a tax credit like J51 is still active in the building? Is that grounds for a potentially successful overcharge claim?
that's an interesting question. So for J51 benefits now, like rent stabilization, like it just doesn't it's not affected by the removal of J51, right? If a building was an apartment was rent stabilized prior to the landlord applying for and receiving J51 benefits, once it exits the J51 program, it reverts back to its rent stabilized status. So I guess I would have to know a little bit more about when the Frankensteining occurred relative to like when it got its J51, right? Because if the landlord got the J51, if the apartment was rent stabilized, the landlord got the J51 benefit, Frankenstein the apartment during the time that the J51 benefit was happening, right? And then it exits in like 2023, 2024 after this law is passed. I would argue that that apartment is still rent stabilized and it hasn't been broken out, right? Like there's no exception for it. I can, I guess, imagine different scenarios where that wouldn't be true. Like, for instance, if it had been Frankenstein and the landlord had claimed it as deregulated prior to receiving J51 benefits, definitely. Or if it had exited the J51 benefit period like in 2019 prior to the enactment of this change. I'm not sure how that would be affected or what the result there would be.
Um, and just a note for everyone, we did an overcharge workshop recently. The video will eventually go on our website later. Um, so another question, what if the landlord did not get proper work permits from DOB for the work done for Frankenstein apartments? Can tenants challenge that? If so, would DHCR investigate that?
That's really interesting. I don't know that that would be a claim that would go against the Frankensteining, but my understanding of the law as it stands now is that the landlord has to provide like the measurements and layouts of both apartments prior to doing the work that Frankenstein's them and when applying for the new rent, right? So if they didn't get the DOB permits, I'm not sure how that affects it, but there are certain things that they need to do to show what the calculation will be based on, right?
Um, and then another head scratcher. To you do talking about surface area of the floor, but does size also apply to the height of an apartment as well?
That's really interesting. I would think so. I think so. The other instances in which DHCR takes a look at square footage and space, livable space, right, in a rent stabilized unit is in rent reduction orders based on reduction of the size of an apartment, right? Same sort of thing happens, say a tenant temporarily has to vacate their apartment due to a vacate order. The landlord does a bunch of work and reconfigures their apartment in such a way that it's smaller. The DHCR has always found that a reduction in livable space requires a reduction in rent. So if you can make the argument that the landlord reduced your ceiling by putting in, say, a drop ceiling or something, um, and has therefore deprived you of livable space, I think you have a good argument at the very least. Wait, Sarah, are you talking right now?
Sorry, sorry. Um, this is a follow-up. I signed a lease to my apartment October 2022. The apartment was Frankenstein between 2020 and 2022. Filed an overcharge application in January of 2023. Would the new closure of the Frankenstein loophole apply to cases retroactively?
No,
If
it
so, would rents be readjusted for cases before the loophole was closed?
Yeah, no, I mean, I'm almost certain the answer is no, right? Because this is a change in the law and not like a change in interpretation to law, right? So, like, yeah, this is an actual change in law. If this were something that DHCR just decided, oh, this is the actual law, we should have been interpreting the actual law this way all along, right? Then you'd have a good claim for saying that it applies retroactively in the sense that it applies now the same way as it applies then. But this is an actual change to the law. So the landlord can't be held responsible or held liable, right, for 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 a law that, was proper and in effect at the time they Frankenstein the apartment.
So I see that there are some other, they might be on kind of slightly off of this topic, and I know that we have other topics to present. So um, if it's okay with you, I'd like to move to the next section of the presentation.
Wait.
Um, yeah, thank you.
Okay, thank you all. Okay. So the next topic is another way that apartments can be deregulated are apartments that have J51 or 421A tax breaks. I'm going to explain what they are. This section I'm going to go through quickly because there's a lot of technicalities to each of these. So this is like a big one where I really recommend getting some legal advice if this is something you're experiencing. But basically both are tax credit programs that incentivize landlords to maintain affordable housing. So 421A is given to, it's like property tax exemption. So that means that the landlord pays less or no taxes for changes they made because of construction or new construction, new buildings. And J51 is a property tax exemption and abatement for renovating a building. So taking a building that needs work and getting like a regulatory agreement with the city in order to rehab the building or improve it. Once the landlord receives either of these tax breaks, tenants become rent stabilized for at least the time period of their tax break. And that could be 25 years, 35 years. These are all things that you would need to look into based on your building. Co-ops and condos are exempt from rent stabilization with these tax breaks. So that's one exemption. And if the landlord, while you're receiving one of these tax breaks, receives an MCI, a major capital improvement rent increase, the rent can be temporarily reduced in the MCI case or later due to the tax abatement modification. It's really important, as I've said before, to point this out to DHCR. They are not going to independently find this information or look into it. But the rent can be restored back at the end of that tax break. Pursuant to like a restoration order. Okay, and next slide, please. Oh, I made one of the links too small. 1 second. Yeah, so these are just some really important links. I'll describe each one. Apologies that I'm live editing. So the first is how do you know that your building's in 421A or J51? Well, first of all, it's supposed to be in your lease, but don't ask the landlord to put it in your lease if they didn't. That's a classic mistake that will help you. I'll explain in the next few slides. But if your building is currently has a 421A exemption, you should be able to look it up on the Department of Finance website, and I dropped the link in there. You could also Google Department of Finance 421A, and you could find the search page that way. And then J51, similarly, Department of Finance. There's also other ways to look into these records, especially for, let's say, you're in a building where maybe it expired last year or 5 years ago, and you're doing an overcharge and it's unclear. And that you could look up on the Furman Center data and subsidized housing database. It's the core data in your NYC. You can also Google Furman Center tax break database and get it that way. I also highly recommend the DAP portal. The DAP portal is like an all-around data subset about your landlord. We use it all the time in legal work. And it's just like a way to look up your landlord, the money, you could look up the regulatory agreement, but on the left side, it will tell you if it has a tax break of some kind, often naming it if it's 421A or J51. So if you put in your address in the DAP portal, you could see rent regulated or status, and you open those up and you could see if they have one of these tax breaks. Another way you could tell, and if you are in a building that you believe is has a 421 or J51, and you're looking into, well, when does it expire, and you don't believe what the landlord is telling you, and it's really unclear, it's really important to FOIL the records, the Freedom of Information Act. This takes, the last time I did this is like 6 to 8 months. So do it earlier, do it as soon as you find out, just so you could have the records. Yeah, you could request it from the Department of Finance. I put in the link, but it forces you to like kind of choose the agency as Department of Finance, and you just put in like one sentence, like I live in this building and I would like to see any and all documents related to my landlord's tax break status with regards to 421A or any other tax exemption. And they'll send you back every document that the Department of Finance has. You could see when they applied for it, when it was approved, and what type of, like how long it's going to last. It's actually a lot easier to understand than the regulatory agreements that you find through ACRIS on the DAP portal. Sorry, I'm using a lot of codes, but ACRIS is the website where the landlord's financing records are, and you could find that through the DAP portal website, which I linked above. Other things are, although these are not the only fact sheets about it, there's also the DHCR and HPD fact sheets on the 421A program, which I linked here, where you could read a lot of what I explained and further. And now I will just quickly explain the process, because it is a little confusing, and these fact sheets do say this, but I wanted to put it in a chart for myself even. I use this kind of chart to understand what can and can be allowed. So how does the 421A program work? So let's say you're living in a building that has its 421A, your landlord's claiming it's expiring, you confirm it's expiring, you get the FOIL records. With 421A, once it expires, your building could potentially come out of being rent stabilized, depending on when the construction took place and whether notice was given. So if you're if the landlord received 421A after 1984, the landlord is required to provide notices of the expiration date on every lease renewal. If they're not doing that, okay, you may be able to use that as a reason to prove that your apartment should stay rent stabilized even after the expiration. So with 421A, if the landlord is giving you all these notices and the notices are correct, once they come out of that program, you are no longer rent stabilized. That kind of sucks. But the way to prove that is to review and keep copies of all of your leases and all the riders. And then this flow chart, I hope you can use for future reference as you're looking at the fact sheets to try to understand, okay, can they destabilize my unit or not? And then next slide, please. I'm just going to quickly talk about J51. So after the J51 expires and the tenants receive the appropriate notices that you're in the J51 program on every lease renewal, the apartment comes out of the rent stabilization status. And if not, the tenant may be able to challenge the deregulation. So let's say you're living in a building that has a J51, you confirm that it has come out of it through these records. If the building was built before 1974 and has more than 6 units, it's probably still rent stabilized, right? However, if during that time, if the rent went up the high rent threshold prior to June 14, 2019, the apartment can still be deregulated through a J51 expiration. A lot of this is being challenged in the courts and with DHCR. So just always get some legal advice on this because it's not as clear cut as is explained here. Now, if the J51 expires, you're in a traditionally rent stabilized building and the rent is not above the high rent threshold, then your apartment continues to stay rent stabilized. If the building was built after 1974 and does not have more than 6 units, and tenants received notices properly that, this J51 expires, it can be deregulated at the end of the tax break. But if they did not receive notices, you can fight that expiration. So I think the biggest lesson with J51, 421A, check if you're getting notices. Do not tell your landlord if you're not, because that's okay. You might be able to use that, keep copies of everything, so that you can show that your building should remain rent stabilized, even if it's a brand new building, like many 421A buildings are. And to challenge a 421A or J51 tax break, the most important, which I mentioned many times, and I'll just repeat here, don't self-evict, don't leave just because you received the notice from your landlord or their attorney or some higher official. You have a right to due process through the courts. You have a right to see through your eviction case, and only a judge can order a New York City tenant evicted. And organize. And if you're not sure about what else to do, just organize anyway, because organizing is what gets the changes to happen. And share information on what you learn about the tax break with your neighbors so that you're not alone fighting it. So that because then you won't be targeted. Keep all the records, verify the information written by the landlord and their attorneys, reach out for help, call 311. And then also inform the family members you have living with you or non-traditional family members, such as like LGBT, or like maybe your aunt raised you like, her own, like her own kid, that kind of thing. Make sure that people know about their right to succeed to your rent stabilization status if you choose to move or if anything ever happens to you. And that's all. Thank you so much.
Yeah, thank you so much. So we're at a tough juncture time-wise. There is 5 minutes left in the normal amount of time, and there is this next section, co-op and condo conversion. I want to be respectful of our presenters' time. Let's see, is this next section yours, Parker? What are you thinking about time-wise?
It is. I can move. I can move quick. If y'all are okay running just a little over. I know the prior example wasn't exactly quick, but this one should be.
Okay. Now, somebody in the chat did bring up the fact that there are various types of 421A. Maybe just to keep it simple, we'll just say if you have 421A in your building and you're kind of unsure which type, please call Housing Court Answers and we can try to look up the details. And if it gets to a point where a person needs more details, we can try to connect you with a great legal service provider like Communities Resist, like Brooklyn Legal Services, etc. So please go ahead, Parker.
All right. So real quick, let's try and do the Spark Notes version of this. Co-op and condo conversion. Co-ops and condos, it's different types of ownership. Like instead of the owner owning the whole building, in co-ops, there's a corporation that is owned by the residents of the building, and they own kind of shares in this corporation that they entitle them to the lease for their unit. And condos are where everyone kind of owns their own individual apartment, like the four walls, and then collectively, the condo owners own the building as a whole. They're both these kind of hybrid ownership structures, where the people who live in the units, or sometimes the owners don't necessarily live there, but hybrid ownership structures. Today's presentation's on kind of the process by which a building gets converted into condos or co-ops, post HSTPA. And conversion from being an apartment that's owned by like a single owner to a co-op or condo, while it can lead to deregulation, it doesn't always mean deregulation for the people living in there at the time. A lot of the time in these co-op and condo conversions, you have the right to remain rent stabilized for as long as you and then a family who succeed to your tenancy are there. It's only after the person vacates that the apartment then turns into a market rate condo or co-op. All right. So in a conversion, the owner, basically someone has to be the sponsor is the term that's used here, and the sponsor has to write out a plan, and the plan has to explain how they intend to convert the building into condos or co-ops, and they have to circulate that plan to the people who live there, as kind of the right of first refusal, and then to other interested parties. And the number that they have to hit is 51%. After the HSTPA, the number was converted to where 51% of the people who live within a building, or the interested parties have to agree to go condo or co-op, in order to get it there. The HSTPA also kind of changed the conversion process to where there's no more eviction plans. It used to be that someone could file for co-op and condo conversion and say that the plan was a so-called eviction plan, where anyone who wasn't buying would be evicted, so that the whole building would be co-op or condo with no remaining tenants. That's now gone. And under the prior law, only 15% of tenants needed to agree for the building to go condo or co-op. Now it's 51%, a significantly higher threshold. And I see within the chat, Alex, I see within the chat that we're talking 15%. I'll get to the affordable housing protection changes from this year towards the end of the presentation. The Attorney General has the power to investigate these co-op and condo conversions, and fundamentally, the AG is the one person who has the authority to approve or deny it. So a lot of the advice we're going to be going through is about whether you can loop in the Attorney General, and the tenant protection units at the Attorney General's office so that they can investigate whether this is being done above board or whether this is fraudulent. The conversion isn't done until the AG has signed off on it. So the sponsor has to submit the offering plan, like basically the outline of what they intend to do, to the Attorney General's office, and they have to send it to all the current tenants at the building. It's called like the red herring packet because it has to have a bright red cover. Nothing to do with like a red herring, the literary trope. People just liked the color. The Martin Act is the relevant provision of the New York law governing businesses and fraud and disclosure. It requires a full disclosure of how the investment's going to work to the prospective purchasers. The current tenants generally are going to have the right to be the people who either elect to buy their unit as the co-op or condo or refuse, before it's sold on the open market, and the Attorney General's office decides whether to approve it. The conversion's effective after both the Attorney General has approved the conversion plan and 51% of tenants and interested parties have agreed to purchase. Okay. Non-purchasing tenants. So if you decide not to buy in a condo or co-op conversion, you retain your rent stabilized rights for the duration of the tenancies, including renewals. until you choose to move out. Families have succession rights, but as mentioned before, when Natalie Tan brought it up, there's rules around succession, the cohabitation requirement, the family, either like was it non-conventional or conventional, you have to still meet those requirements. So it's not like your family can just move in the day you move out. But as long as you're complying with the other rent stabilization rules around succession, your family can succeed to your rent stabilized tenancy in a building even after it's been converted. But otherwise, once the rent stabilized tenants move out, the apartments can go and become market rate. Challenging. As mentioned, the Attorney General's office is the one who can step in. They're the one who have the ultimate authority to approve or deny the plan. But similar to DHCR, the Attorney General is in Albany. They're not in New York City. They have people down here, but they're not going to see something unless you draw attention to it. If part of the plan is shady, tenants need to let the Attorney General's office know that part of the plan is shady. Some shady things I've heard of historically, there was an example where the owner had a bunch of friends move in and become tenants. And then suddenly, when they circulated the offering plan, a whole bunch of tenants were like, yeah, we want to sign on. It's like, no, these are parties who are like either from the landlord or working to their benefit for it. And if the Attorney General's office isn't notified, then the Attorney General can just sign off on it. Um, as with everything else here, collective action is going to be key. There's been instances where a tenant association coming together and making like a communal no-buy pledge, where 51% of the tenants in the building say we refuse to go co-op or condo, then that can be potentially enforceable in court as like an agreement, a contract that everyone's bound together, and that can be used for leverage. If it seems like the building's going to go co-op or condo eventually, that sort of collective power can be used for leverage for better terms in the co-op and condo agreement. Something like a place in the bylaws of the condo board for the rent stabilized tenants to have a voting share, something of that. So by organizing, you can work out better terms for non-purchasing tenants. As before with everything else, you can also reach out to Housing Court Answers for connection to other legal service providers and advice for what more can be done here. So yeah, the wrapping it up, the DHCR is not really going to be a party in this. Like it's mostly between the Attorney General's office and the tenants. And even if the plan is uh yeah, even if the plan is approved, the non-purchasing tenants retain their rent stabilized rights. As long as rent stabilized tenants are there, DHCR can still do things like harassment, overcharge, um, rent reduction orders, all of that for your rent stabilized apartment for the duration of your time as a rent stabilized tenant. Um, Now, lastly, there was recently the AHRA, which I'm trying to remember the acronym. It was like the Affordable Housing, what was it? Um, was it
Affordable
Affording
housing
Housable
retention.
Retention Act. Yeah. So the AHRA has created a new method by which co-op and condo conversions can be done with the 15% threshold. It also requires numerous other state agencies be involved. It added some sections to both the general business law and God, one other ones. I haven't gone super deep on it, but basically it's created a new way for large buildings, more than 100 units, not currently already subject to a RED agreement, not currently already subject to a Mitchell-Lama um, or other non-condo agreement. And on top of it, there has to be a partnership with a like a public-private partnership and nonprofit core uh, to help shore it up. As I've read all of the press releases that I've seen for this AHRA statute have been it's another pathway. Not that the press releases, as I've seen it, have not been that like this creates new protections for buildings. It's mostly been how this creates new opportunities for owners to try and do co-op and condo conversions. But most of the landlord firms that have been kind of trolling their websites on it have been coming down on the side of, well, yes, in theory, we could do a 15% conversion, but there's now a lot more state agencies involved, a lot more oversight. If you can still do it with a 51% conversion, that way is going to be easier. So it's created like a new alternative pathway for it. If you are looking at if you are in an instance of a building that's under one of these AHRA conversions, definitely reach out to housing court answers. Definitely reach out to legal service providers because the public-private partnership kind of involvement aspects of it make it very building dependent and very fact dependent compared to kind of the general aspects of the Martin Act.
Wow, and it sounds like this is so new that maybe we'll have to bring you presenters back next year to give us an update on what you've observed regarding this particular topic.
Oh, and then sorry, just to circle back
Mhm.
to the question I didn't get to answer during the demolition. The apartments need to be substantially similar, like similar size and floor plan and square footage. So it's not the way I read it, it's not a bright line rule. It's not that the apartment has to be the exact same number of bedrooms or the exact same number of square feet. But if they were taking you from a 3 bedroom to a 1 bedroom, that probably wouldn't meet the criteria. Whereas if it was a 3 bedroom to a 2 bedroom, with roughly the same amount of square footage, that might satisfy the criteria. But it's not a bright line rule on relocation during demolition.
Yeah. Thank you so much for looking into that. And so we are over time, but somebody asked in the chat, will this webinar be accessible for viewing after today? Absolutely. We have recorded this presentation and we are going to put it into the Housing Court Answers YouTube channel where you can see many videos that we've done on important topics. And additionally, we'll put it on our own website as well. So it can be viewable by people here, by future tenants who only discover this issue later on. Please share the information with your friends, your neighbors, folks that you organize with, because information helps people um, figure out the smart ways to fight their fights. So Sam Kira had to leave us, but I wanted to say thank you to Natalie and Parker from Brooklyn Legal Services for giving us this rich presentation with so many different kinds of information that tenants might need. Yeah, and oh, excellent. So thank you so much for being here. And also thank you to all the participants for helping the presentation be even better with your excellent questions. So yeah, keep checking the Housing Court Answers website so that you can get more information and check out our future. This is the last presentation of our spring training series, but we will be back at it again next year as well. So thank you everybody for being here. Keep getting more information. Okay. Bye all.